Hello, hello. Good evening. Good evening. Can you hear me, Captain? Can you hear me, Captain? Can you hear me?
I can hear you.
Great. Can't hear you, Jimmy. Okay, good.
Hey, everybody. Hi, Richard. Hi, Bernie.
We're
Hello.
here. You can get on?
The chief will be on in a moment.
Okay. I just got finished making and eating some corn chowder soup. First, black bean corn chowder. First time I made it. Hello, Janice. How are you? We can't hear you.
Sorry, can you hear me now?
Yep.
Thank
Good
you.
evening.
How are you?
Great. So we're waiting for Marie. Hello. Oh, no, that is it. Hello, who's 3523? Here's Marie. Who is 3523?
Thank you, Derek.
I don't think it's Wade. Is it Patrick? Patrick, is that you? 3523?
Hi, could it be me?
No, you
No,
show
it's
up as
not you. You're showing up as your name. You are you. I may knock this person off if I don't know who it is. They don't respond.
Karen on?
I don't see Karen. I don't know if
But
that's
she
her.
said she was gonna call in, so.
Well, this is a call-in number. Maybe she can't speak.
it's 914-574-3523. Maybe that person can identify themselves or put something in the chat.
Yeah, I'm gonna put something in the chat. See if that.
No, that's Karen's cell phone
That's Karen.
number.
Yes.
That's Karen's cell phone number.
All right. So the only person that is not on, well, we don't have Wade on, and we don't have Patrick.
Hmm.
Let's
Can
give
we
it.
text
Give it
them?
one.
Well,
Yeah, I'm gonna call.
Didn't Wade say he couldn't make it? Didn't Wade say he couldn't make it tonight?
Yes.
Yeah, you're right about that.
Oh.
And I can't get through to Patrick. I don't have his direct number. If anyone else does, I don't. I just had his office number. So, but we can proceed, I think, and hopefully he'll jump in at some point. So, we're all here. And know that Karen's not on the line. The reason that we're getting together is to go over our recommendations once again, based on what Karen had and Janice had included in the document that's going to be put together for the overall committee. And maybe it would help if Janice, it would be good if Karen was here and we could reflect on that. But be that as it may, maybe I should just throw it over to Chief Castelli, and you could start us off with, because I believe that we have gone over our documents over and over and over again. And I thought that those things that we had cited in writing, Karen had put together with Janice. And I think from our last general meeting, although I wasn't there for the entire thing, I think you had gone over it again. Although I think that there was some outstanding issues that at that meeting and after, I was felt by Karen and others, other than those in the committee, that we should review them again. And with that in mind, Janice, I don't know if you want to pick it up from there, or.
No, you could go ahead. Karen had sent everyone the recommendations that were in question. And I think that we have the chief and the captain on, right? So they're gonna go over some issues that they had with some of the recommendations. In particular, there was a few that Richard had. I think we should start with those first.
Okay. You want me to start?
Yeah.
Just from last week, there were a couple of recommendations that Richard had proposed that we needed. I guess he wanted clarification because they weren't in the report as he wrote them. So maybe Richard could probably be the best person to start off with the recommendations that he had issue with in the draft report.
Okay. So what we noticed in the report that was circulated before this last meeting was that some of
Bernie, Karen said let her in. She's in the waiting room.
All right, I'll look and see. I don't see it, but give me a second.
Sorry, Richard.
It's okay.
Having a problem with my mouse. Okay. All right, here we go. I just admitted her. Okay, Karen is in.
Very good.
Hi, Karen. All right, Richard.
Okay. So what we noticed is that the document that was submitted to the committee as a whole that was titled, I guess, White Plains Police Reform Report, did not contain the recommendations of the subcommittee on two of the White Plains Police Department policies, the field stop policy and the response to resistance policy. And what we received was what were referred to as annotations to the form that we use to create some of the recommendations that were submitted by the subcommittee. And those recommendations were changed. And so the annotations sort of reflected those changes. And in those two areas. So the document called the White Plains Police Reform Report, when it comes to field stops, did not recommend deleting paragraph 2B from section 12102. So I know this is a little bit complicated, but the field stops 12102 has section 2 for reasonable suspicion, and this is under the topic of forcible stops. So the law is that a police officer may conduct a forcible stop, as opposed to a stop and frisk, but a forcible stop, if the police officer reasonably suspects a person has committed, is committing, or is about to commit a crime. Could be a felony or a misdemeanor. That is listed correctly under 2A of the policy. But then 2B of the policy defines reasonable suspicion as an alternative, as when an officer reasonably suspects criminal behavior exists, which can be based on past articulated experiences. So let me say that the committee discussed this at length, including the discussion from Patrick McCarchick, an assistant district attorney with the Westchester County District Attorney's Office. And he agreed with me that 2B is wrong because it provides a policy which would presumably be taught to White Plains officers that they may forcibly stop somebody based on an officer's reasonable suspicion that, quote, criminal behavior, undefined, exists, which can be based on past articulated experiences, which could be anything. And this, we believed, the committee agreed that 2B should be struck because it is wrong. It's not legally correct, and it's confusing because it's, it takes away from the rather simple the definition of reasonable suspicion to justify a forcible stop, meaning that the police officer reasonably suspects the person is committing, or is about to commit a crime. That's when you get to forcibly stop somebody, as opposed to what is referred to in the law as the common law right of inquiry, commonly like, what's all this then? Or, what's going on here? Something like that. That's a right of inquiry. This is a forcible stop. So that's number one. And then there was a separate issue having to do with frisks.
So, but Richard, should we first go over that one and
Sure.
satisfy that?
So the first issue was this 2B, eliminating 2B.
First of all, I do want to apologize for last week's not being able to stay on the Zoom. I tried, but I knew about the 2-hour mark where I was going. I was gonna hit problems. So I certainly do apologize for that. So my only issue with 2B and again, I guess it's the interpretation of the reader. The point that's trying to be made there, and that's why it was I kind of recommended we move it under facts that help establish reasonable suspicion, is that the experiences and the knowledge of an officer's prior experiences can lend one of the factors toward reasonable suspicion. That's why I recommended that it be moved. My point being is that, you know, using the example of an officer who has seen X amount of drug deals and they are, you know, a high drug location, somebody on the corner, somebody pulls up, a transaction is made and the car pulls away, that, you know, it may be a different person, but the acts of itself and the officers are, you know, again, using the wording, his articulated experiences would give him reason to reasonably suspect that a crime is being committed. That's the police interpretation of it. I don't think that is in conflict with the intent of stop and frisk. That's what, but under the circumstances, I understand what a little bit of what's being said. So my thing was, if it's that big of an issue, I do believe articulated experiences, the knowledge, prior knowledge of a police officer is relevant under facts that may help establish reasonable suspicion. That's why I said maybe if we move it here, let's see what the committee thinks about that. So I know, Richard, you say that it is wrong, but you know, we're talking about reasonable suspicion exists, and the officer is basing that on some, obviously what's going on at that present moment, but also on articulated experience. A guy in a parking lot shaking door handles could be innocuous activity, but based on prior experiences, we know that many people are looking to steal out of cars. So we approach that person with reasonable suspicion that a crime is being committed based on a lot of what we know prior. And again, I'm not a lawyer, so I'm just going by my training, how we put this this part of our policy into effect. You know, I had opportunity to read Terry versus Ohio because you brought it up. I mean, I certainly knew about it, but you know, to me, it does mention in various parts of it about the officer's experience and the inferences that an officer can make. So
That's correct.
that's kind of where my issue with the thing was, where if the placement of it and I don't believe it's wrong. I just maybe it would be better under facts that can help establish reasonable suspicion. Would be the officer's articulated past experiences, observing crime, arresting people for crimes, patterns and things like that. That's where my not my argument, but what my perspective is that I wanted to get out.
Okay, but I mean, you could, the problem with the sentence is that it says that reasonable suspicion is when an officer reasonably suspects criminal behavior exists. So criminal behavior exists is getting away from, do we reasonably believe this person is about to commit or has committed a crime? When you say criminal behavior exists, that's really vague, and it detracts from what the police officer needs to know before he can make a forcible stop. So that's number one. Number two, of course, police officers' experience is what, when they see something, they can articulate, you know, later if they're called upon in say at a suppression hearing to explain why they thought they had reasonable suspicion that the person was committing a crime. And if that person, who's the police officer, says, well, I've seen and I've learned that people go around testing door handles because they might be, you know, going to try and steal something from somebody's car, that's perfectly 100% understandable. But it's just the way this sentence is written. It you know, when you say past articulated experience, that could mean anything. But I think what you're getting at is that, you know, a reasonable suspicion can be based upon, you know, what the police officer sees in the context of his experience and training. But
Yeah.
that would be different from what this actually says.
Well, I mean, again, I'm not gonna argue the fact that your interpretation of it or my interpretation of it. My point is if we're gonna make a recommendation and my offer was to try to put this in better context and put, articulable, past articulable experiences under facts that can help establish reasonable suspicion. As just an element of that, I think that would, we're both agree that an officer's experience is relevant to establishing reasonable suspicion. So if it's the actual wording, I was just offering to put the fact that the officer's experiences are relevant, let's put it under the facts that can help establish, as opposed to striking the whole concept in and of itself. That is kind of what I got out of the recommendation. And, maybe the wording was not right where we put it under made it number 4 and just said articulable past experiences with crime. I mean, maybe that's understood by
Well, I
us.
mean, you could just say articulated facts in the context of police training and experience, such as. In other words, you could amend C to add in the context of, police experience and training or officer experience and training, because I think that's what you're getting at. When you start talking about past articulated experiences, then it's like really confusing as to what that is. And also it talks about suspecting criminal behavior exists instead of suspecting, a crime is that a person has committed, is about to commit, or, is committing, is about to commit, or has committed a felony
So,
or misdemeanor.
so my issue is only that the concept, the way I look at it is that this was trying to establish that police experience is relevant. If we agree on that, then maybe the wording under C or under the facts that help establish reasonable suspicion, as long as we document that police experience is a valid piece of establishing reasonable suspicion. That's
Yeah,
all.
I
I mean,
think we're all saying the same thing.
Yeah.
But the outstanding issue is Richard's point of criminal behavior exists. So is there a way that can we change that? The recommendation would be to say something like a crime has been, is being, or is about to be committed.
I think all you need to do is, if you look at C, it says must have articulated facts. It could just say in the context of officer training and experience, because that's really what you're talking about.
We're there with you on that.
Okay.
So you can just strike
I think
B and just add, training and experience to C.
That's fine by me. I'm writing it. So let's say we get rid of B altogether, let's say. Now C becomes B and we add number 6 that must have articulate face such as context of officer training and experience.
Yeah, but you could have, what I'm saying is if you where it says C now, must have articulated facts, you
Right.
could just put must have articulated facts in the context of police training and experience, such as. That way you could just put it in the title, because all the facts are going to be in the context of police training and experience.
Well, I mean,
It's not a separate thing. It's part of what they do.
It delineates other stuff. I mean, the information from victims 911. So to me, the training and experience is a separate factor in and of itself. It's not the broad catch-all. It is a piece of the puzzle, including 1 to 5. And I would even say they would not. We're not trying to be all inclusive on what these are not the only articulated facts. So I understand what you're saying, and I just think that making it just a number 6, that officer training and experience is maybe a part of one of the articulating facts that gave rise to reasonable suspicion.
Okay, yeah, but I just think that it can say, it could just say, officer training and experience, but what my objection to B is that it is
Right.
contradicts A, and it's really, what a police officer who read this could think like, well,
Well-
if I didn't like that guy in high school, that's a past articulated experience.
Well,
And I thought he was no good then.
well, Richard, I understand what you're saying, but it's, everybody seems to say that we throw these things out there for the officers to read and interpret as they see fit. I can just tell you that that absolutely is not the case. I understand that in the general sense that wording may not be to a layperson's liking, and I can agree with that. I could just tell you that we don't we explain that, and we explain what it means. If putting it in another part of this procedure clarifies everything for us and makes it a relevant recommendation, that's all I'm trying to get at. You're trying to say that an officer can say, I don't like that guy from high school because I had a bad experience with him, is out of the context of what we do in police work. But it shouldn't matter at this point. I think we both agree that B is somehow defective or could be made better. Let's put it in under articulated facts under C, or under facts that can help establish, and move on. If we come up with the wording that is the most appropriate or the most effective wording. So
Okay, well, so the committee recommended that B be struck. What you're saying is that you would like to take something from B and put it into what would now be B in a separate thing. So if you want to make a suggestion as to what language you would like to have there, I've made a suggestion, but if you would like to have one of your own, then you could circulate it to us.
no, I do think that, to make it simple, I mean, it has to fit the format, in terms of make sense, but in the context of officer training and experience, it just needs to be cleaned up. That's pretty much what you said. I don't have a problem with
Okay,
that. It just must have articulated facts such as in the context of officer training experience. If that
Okay.
makes sense, I think that's fine.
Yeah.
Gentlemen, it's Karen. Hi. So right now, what I did was I said amend section 12102 to remove a paragraph 2B and move it
no,
to
we're not moving it. We're adding we're taking some language.
remove. I said
No.
remove.
But we're not adding the whole thing from B. What we're doing is putting in the context of officer training and experience.
I
You should
know.
let her-
Would you
Why
let
don't
me
you let her
finish,
finish?
please?
All right.
Yes. Remove paragraph 2B and move it to the current subparagraph C, and to say must have articulated facts such as, and we're adding as perhaps a number 6, in the context of police officer training and experience.
Karen?
So we're saying that it would be moved to what is currently subparagraph C, which will become subparagraph B. And we're adding a number 6, which would read in the context of police officer training and experience.
Karen, I think, this is Bernie. I
Yep.
think that what is being said, that it not be moved at all, that it be rewritten and in another section to qualify the issue in another section, but not that if you say that it's going to be moved, then you're actually picking it up and moving to another section versus it being rewritten with more explanatory language in another section. I would not say that it's going to be moved.
All right, so we're removing paragraph 2B and adding to the current subparagraph C, right? A number 6, which says in the context of police officer training and experience.
Okay, so I'm just going to say that then it therefore would read, must have articulated facts of such as skipping to 6 in the context of police officer training and experience. So the problem with that is that the sentence
It doesn't read well,
That's
yeah.
what I was trying to say. If we have a better syntax, whatever the word is.
Well, that's why I suggested that where it says C must have articulated facts, we could just insert in the context of officer training and experience, such as, and then we have a non-complete list, examples of information.
But I understand what you're saying, but to me, it must have articulated facts such as context of officer training and experience. And then to me, that would read that all this other stuff, 1 to 5, would somehow be part of officer training and experience. And in a way it would
Right.
be, but a lot of these are also independent facts.
Well, we're talking about the articulated facts are always interpreted by the officer's experience. So if you see somebody
That's not true.
like, like
It's not
casing a joint and you have experience, whereas, somebody who's not trained might see somebody walking around the outside of a liquor store, you might, if you're a police officer, you might be suspicious that this person is going to try to rob the liquor store.
I understand what you're saying. I think we're getting deep in the weeds here, but you said everything's interpreted by an officer, and that's not accurate. Facts are facts. A 911 call that says John Doe just shot me is not interpreted by an officer. It's a fact. That is an independent. So I would like to leave the officer training experience as an independent bullet point under articulated facts.
Well, but okay, how is officer training and experience an articulated fact?
It would be based on my training experience and my knowledge of packaging of drugs and observing drug sales and articulated facts. I can't tell you what an articulated fact is. Absolutely a general term. That's what the officer has to do, is articulate why he believed he had reasonable.
Oh, no, I know that, but what we have a list here of articulated facts, and you're saying that you want to put down officer training and experience as an articulated fact.
Right. These are things an officer must articulate in a report in order to substantiate why they had reasonable suspicion to stop and question somebody, and then go from there to give the legitimacy of the original thing. One of the factors, not a sole factor, would be the officer's experience with that type of crime, with that type of activity, with certain actions.
Okay. So what you're saying is the articulated facts must have articulated facts such as, not in the context of, but just officer training and experience. Because you think that articulated facts can be just officer training and experience.
Observations based upon the officer's training and experience. Yes, there's a distinct difference between a police officer with 1 year experience on a patrol, as opposed to the training and experience of a 20-year narco detective. So the narco detective could call from his years of police experience and training differently than a 1 year rookie could call from the same thing. So yes.
I think that to make it sound right, this is what I'm proposing, and please, I mean, anybody make the recommendations that B goes away, C becomes B, and we add number 6, which would say must have articulated facts such as officer training and experience. Does that make sense now? Well, as number 6, along with all the other ones, just to make the sentence sound
right. Okay.
I'd have to see it.
Okay.
I don't have it right in front of me, so I'd have to see it. And
yeah, the way it would read is must have articulated facts such as 1, 2, 3, 4, 5.
Yes.
And 6 would be officer training and experience. I mean, I don't want to, get into, a big dispute about this, but I would have to say that it's the facts in the context of the police experience and not the police experience alone. So even if the police officer says, well, I've been at this 20 years and I've done 1,000, buy and busts or something like that. It's still the facts that he's observing on the street that in the context of his experience causes him to have a reasonable suspicion that, that there's a crime going on. I mean, but, that.
I agree.
I don't
I
know.
agree with that. I agree. So it would be observations based upon the police officer's training and experience, correct?
I'm sorry, I couldn't hear you again, Jim.
Wouldn't it be observations based upon police
Yes, yes.
training and experience?
All right,
So
so
yeah,
It's
observations based on officer training and experience. Does that sound?
yes.
I want to jump in here if I can. So I'm listening to all this, but I just had to pull out the policies and procedure manual because I want to see exactly what you're saying. Where, I'm just
It's
looking, it's at
on the
12.
bottom of, it's on the bottom.
12102,
12102, what is this? The third,
forcible stop,
what page is this? Under forcible stops,
First page.
12102, see
first
that?
page.
Yeah, it looks like the first page, the bottom of the first page.
2B and C.
Do you have it, Marie?
Not yet, wait. Is it before or after firearms?
It's PR 121. Get to PR 121 first.
Field
You want me
stops.
to email it to you?
It's just that one, can you email? Can you just text me, take a picture and text me the page that you're talking about?
No, I'm going to email it to you right
Yeah,
now.
email it to everybody.
Okay.
Sorry, I'm eating at the same time.
Okay. You want me to email it to everybody?
Yes, please.
Okay, so this is
Okay.
12102 forcible stop?
Correct.
Okay, I found it. Sorry. I think.
Okay.
Okay.
So it's going to Marie, Bernie, Janice, Karen, Wade. Oh,
You don't have to send it to
Marlene?
me.
I have it.
Richard, I
I
have
have it.
it. You don't have to send it.
Okay.
I also have it.
I also have it.
Okay. So just Bernie, Marie, Marlene,
She has
No,
it.
I have it.
Wade. Send it to
and
Wade.
Wade.
Well, Wade's not on here, but
But
Wade's
he'll
not
get
on.
it anyways, just so that he
What the
has it in
hell?
documentation.
It's okay. Okay, I'm sending it. By the way, I got an email from Pat McCarchick that says he's on another Zoom for police reform in North Castle. So that's why he can't join us.
So what do we, chop liver?
Yeah,
Right.
right.
What's more important, police reform in White Plains or police reform in North Castle?
Yeah.
I would say police reform in North Castle.
Yeah, apparently.
Thank you for giving me that opening, Karen. I owe you 10.
Okay, so
All
I'm
right.
is this 2B when an officer okay, so in my notes, when we first
We're
started this, I wrote a big omit on the side and a big X,
Right.
which is what we, I guess, talked about, what we had made the recommendation of.
So we're removing paragraph 2B and we're adding language to what is currently paragraph 2C. The chief is proposing that we add a number 6, which says observations based on police officer training and experience. So the paragraph would read, must have articulated facts such as, and number 6 would be observations based on police officer training and experience.
Janice, what do you think?
Sounds good to me.
Marie,
Yeah, so wait, say that again, number 6, that what you wanted?
Observations based on police officer
Okay.
training and experience.
Okay. How about like articulated observations?
Well, it
Well,
already
the
says
first
C.
line is articulated facts such
Oh, okay.
as.
Okay. Yeah, I think that's fair.
Okay.
Okay. Okay, it's done.
Okay. So you want to move on to the next issue now?
Yes.
We've killed that?
Sorry, Bernie.
Mhm.
We've killed that, right?
Yeah, I think we have completed our discussions with respect to that matter.
Thank you.
So the issue next has to do with frisks. And this is under 12-103, Law Regarding Frisk.
Oh.
This is on the next page. Law Regarding Frisk. Do you see it?
Yep.
Mhm.
Okay. And then skipping to 2. Not all stops lead to frisk. Double exclamation point. Okay, and then skipping, it says there is a need to articulate why the subject was frisked. Okay, the next 2 sentences are problematic. You may frisk for a weapon if you reasonably suspect you are in danger or that a weapon is present. All violent felons, those using weapons or force, can be frisked. Okay, so what Terry says, and when I say Terry, I'm referring to a case from the United States Supreme Court, which I circulated to the members of the committee from 1968, in which Chief Justice Warren provided that as a means of protecting police officers, that they can, after they do a forcible stop, and we've gone over what that can be, if a police officer reasonably suspects that the person that they have forcibly stopped is armed and dangerous, they can be, the outer part of their clothing can be touched or frisked. It's not a full-blown search. It's a pat down, sort of a frisk. Okay, I mean, this is like, you can, tell the person to assume the position and then you can frisk them. So the problem here is that it says, if you reasonably suspect you are in danger or that a weapon is present, but the law says, if you reasonably suspect that the suspect is armed and dangerous. I mean, that's what it says. It also does not say that those suspected of committing violent felonies, those using force or weapons, can be frisked. It doesn't say that. So many people who are reasonably suspected of committing a crime involving the use of force, say, a fist fight, aren't necessarily thought to be armed and dangerous. And so the issue is that this policy is legally wrong and could permit, and if a police officer was following this, they might say, well, I felt I was in danger because, I just had a feeling that the guy is a bad guy. I felt I was in danger. I reasonably suspected I was in danger. But in order to sustain a search, you would need to, so that if the police officers, did this frisk and they then found contraband or a weapon, in order to justify the search, the officer would have to say why he thought this person was armed and dangerous. One reason could be that somebody said that person has a knife or a gun or some other weapon. That would lead to reasonable suspicion that the person might be armed. Or if the officer saw a bulge that was suspiciously like looks, in the shape of a firearm. Or, I mean, there could be a lot of different things that could cause a police officer to think that somebody might be armed and dangerous. Not the least of which would be, say, a 911 call from somebody saying that, the guy standing on the corner of Quaropa Street is, has a gun. But, so the point of the recommendation was that these two sentences are legally in conflict with the law and should be changed.
So.
I mean, that last sentence is completely unnecessary anyway.
So I agree with you that that the or should be changed to and. So you may frisk for a weapon if you reasonably suspect you are in danger and that a weapon is present.
Yeah.
Does that sound right? That
Yes.
is my, after reading some of the things that I've read, that seems to validate that part of the sentence.
Yeah.
Okay. Now,
That's probably how it was written in the first place.
Yeah.
But
but
You agree.
again, Richard, I know you gave an example about a hunch, and I just like to clarify, the policy right there says there is a need to articulate why the subject was frisked. So right then and there's no hunches. We require our officers in a report to write why they did what they did, not after the fact, not explain it verbally. When we do things, we train towards this. So that way we're legally sound and what we're doing is valid. So that way, they need to articulate. I can't stress that more. They need to say, this is why I did what I did. And listen, when there are times when it's sketchy, we will retrain. We will retrain that officer to say, this is no good, and this is what we need, and we'll refer back to this. And we may even put a sergeant, right with a sergeant, so a sergeant can monitor this. But that I don't want to get too far off the topic.
No. Look, we're not criticizing, the actual way that you're policing. What we're saying is that, for example, it's wrong to say anyone who is accused of a violent felony can frisk. That's just legally wrong.
I'm just so I'm not saying this is the end all be all, but I have reference manuals and we look at stuff and I've known this from my training in the past, and I wish I had a better reference, but this is a blue to gold law enforcement training 2020 edition, search and seizure survival guide. And under legal standard for a suspect may be frisked for weapons under the following circumstances. And it goes into things we talked about in the third bullet point here. If the subject was stopped for a violent crime or one involving weapons, an automatic pat down may be conducted. So that's the basis for when we talk about violent felons. So
unless that was written by the Supreme Court of the United States, it conflicts with what Terry says.
Okay.
So the problem is that if your officer follows that advice and they find a weapon on somebody, then the state Supreme Court judge or whoever is the judge deciding that could suppress the evidence because unless the police officer was able to articulate why he thought the person was armed and dangerous. I mean, obviously, if the person was using a weapon, then that might be good. But if the person is suspected of using force during a crime, that in and of itself is not good enough.
Of course, we're using a violent felony. So, I mean, the one circumstance I can see is if somebody, beat the hell out of somebody with their fists, that would still be a violent felony. You're talking about assault 1, assault 2, or assault 2, serious physical injury, and we stopped them. That would probably be the only area where the force this.
Well, what about a sex abuse? What about a forcible sex abuse or a rape case? Force is an element of that offense, but it's got nothing to do with, unless the person said the individual was armed and raped them at gunpoint or something.
Okay, it's a fair point. It's a fair point. I'm not arguing, that you referenced Terry, and I don't know enough about Terry. I'm just, this is not the only thing that I've read that, our training has told us that if we stop somebody, who has committed, a violent crime involving weapons. Now, this says, that it's an automatic frisk, especially the weapons part of it. I can look at this.
But that's different. I mean, this thing says all violent felons can be frisked.
For a violent
That's what
crime. If
that-
the suspect was stopped for a violent crime or one involving weapons, an automatic, I don't know, maybe it's based on precedent law, case law after the
I'm
fact.
telling you, it's wrong.
Okay, well, then the book is wrong. I would
Yep.
just say, give me the opportunity to see why this book, which is, it's not a fly-by-night publication, that I think they do their research also, that why we train that way. Before we just turn into a recommendation that we may not see as safe for officers. We're taking away the ability of an officer to use a tool when what we're talking about here is a safety measure when it comes down to it.
But Chief, can I ask the question?
Yes, sir.
If this is something that is law, it's written in law, whether the book has it or not, shouldn't we be looking at whether or not it actually follows the law, the
I
letter of
agree.
the
Well,
law?
that's what I said. I just asked for the opportunity to see why this book has this here. And where the origin of why it's not just White Plains. This is a common policy amongst law enforcement that violent felons and certainly those who have can be automatically patted
Okay.
down.
Can I jump in here? How about instead of saying all violent felons can be frisked, how about anyone committing a violent felony can be frisked?
No, because that's the same problem. It's not whether the police officer thinks the person has committed a violent felony.
No.
It's whether the police officer reasonably suspect the person is armed and dangerous. That's what Terry says.
How
It's not about the police officer believing the person has committed a quote unquote violent felony.
it has nothing to do with the police officer believing anything. It has to do with the circumstances and the facts and
No, it does have to do with the police officer, respectfully.
well,
It's about reasonable suspicion that an individual is armed and dangerous. That's when a frisk is
well, you
permitted.
said if an officer thinks somebody is a felon, it is you're watering it down when it's to your argument, and that's where there's a little contention here. This is not anything but trying to provide an officer with the means to pat somebody down if they feel that there was a violent felony committed, and what's the word? Not in the time frame, not days, months, weeks, but generally in the time frame of just occurring. That is the purpose of this. And
Well, if they believe that a person had committed a violent felony, they would be arresting them and searching them incident to arrest. It wouldn't be a frisk.
okay, so maybe I mean reasonable suspicion, Richard.
Yeah, I mean, this has to do with not whether, of course, if a police officer believes somebody has committed a violent felony and has probable cause, he thinks, to arrest that person, then he's going to arrest them. And of course, there's a search incident to arrest. We're not talking about that. We're talking about frisks.
I understand that. I made a mistake when I said believe, okay? I don't need a lecture on probable cause and reasonable suspicion. It was a mistake.
I'm
My
sorry.
point here is make the recommendation if that's what you feel you need to. In the meantime, it will give us the opportunity to evaluate what we wrote and what I read in some of these other training manuals. And if it's a valid thing to recommend and change, and I know you're talking about Terry, I'm just saying that I think Captain Spencer can back me up that we have had this training, and it's not just a contrived notion that we put in there to give our officers a little bit of an extra edge, so to speak, that this is something that is standardized. And so you want to leave it as a recommendation that certainly, the subcommittee's power, there is an implementation process that may give us the time to do research on my end to find out if the violent felon part of this holds any water. If not, we'll change it. Is that
Okay.
fair? I mean,
Sure.
Yeah, this is still a
So,
recommendation.
So at this point, we're recommending that the section read, not all stops lead to frisk. There is a need to articulate why the subject was frisked. You may frisk for a weapon if you reasonably suspect that you are in danger and that a weapon is present, as opposed to or.
Right.
And then we would remove the final sentence, which reads, all violent felons, those using weapons or force, can be frisked. We're saying that sentence should be removed in its entirety.
Yes.
Is that correct? Is that an accurate?
Yes.
How about, okay, can I just, maybe a simpler way to say it is, you may frisk for a weapon if you reasonably suspect that a suspect is armed and dangerous.
I think we say that in the first.
Instead of saying that you are in danger or that a weapon is present.
Well, it's not or anymore, it's and.
Right.
So we changed the or to an and already.
Oh, okay. So I'm gonna say suspect that a suspect is armed and dangerous. Okay.
Armed and dangerous.
Yeah, it's the same thing it's the same thing, really. I mean, whether
It
it
is the
says you
same
are
thing,
in
yeah.
danger and a weapon is present or armed and dangerous, it's the same thing. So it's either way, it's fine.
Okay.
Trying to simplify it.
Yeah, I mean, the reason that armed and dangerous is a little broader is because the danger could be to third parties and not necessarily the police officer.
Right.
So it's actually a little broader to say armed and dangerous. But okay, either
Okay.
way.
Question, is there any need to reference Terry in this subsection?
Yeah, Bernie, I think, I have a longer goal here of after the recommendations are in, I'm trying to redo our policies and procedures, inspired by this committee, or at least partly some ideas from this committee. And one of the things would be include relevant information. I think that we are definitely going to include a reference to Terry versus Ohio and maybe some other applicable court cases.
That would be good.
That,
Richard, what's the site for Terry v. Ohio? Is it?
It's I have it here. 392
392
US 1,
US 1.
1968.
And 1968 goes in parentheses, if I'm not mistaken?
Yes.
Yeah, okay, thank you. 392 US 1, 1968, got it.
That's correct.
All right, okay.
All right.
Okay,
So I think that's it for the field stops.
yeah,
Um,
okay.
We made some other points about bags and everything, but I think that's incorporated. The bag searching, I think that's incorporated into.
I believe so, Richard.
Yeah, I think so. So I think we can move on. Are we ready to move on to the other policy?
Yep.
Yes.
Okay. And so the other policy is the response to resistance policy.
All right.
Okay. And so the issue here is that what the committee was saying is that let's take a look at what's in the policy that you have here. It says may result in discipline, violations, and so forth. What our policy started out with for response to resistance, that the current policy says all members will not use unnecessary or excessive force. And what we wanted to say was the policy should be that the use of excessive force is prohibited and illegal. Instead of saying will not use it, we're going to say it's prohibited. I think it's just a difference in emphasis, but rather than saying don't use it, I think we should say that it's both prohibited and illegal.
So,
Because,
Is there any particular place where you're getting that from, where you're pulling that
in
from?
the
Richard?
introduction,
Okay,
in the second paragraph of the policy, it says the use of excessive force, parentheses, illegal or unreasonable use of force can cause serious injury and death. It does mention illegal, so,
Yeah.
what we were talking about is the use of excessive force is prohibited and illegal and can cause serious injury and death and lead to. So we just changed the structure of that sentence to say that it is prohibited and illegal. I think we did talk about levels of may lead to discipline, including termination and referral for prosecution. Did we talk about that already?
I
think
think
we
the
talked
question
about
was
that at the
asked,
beginning.
yeah.
Yep, didn't we deal with this?
So I think we
Yep,
so we may
it's there.
have covered. I think that and you guys tell me that changing that use of excessive force is prohibited and illegal and can cause serious injury or death, etc. And then add that. I thought we added somewhere that the use of excessive force may lead to discipline up to and including termination and referral for prosecution.
We did. That's what we proposed.
So we,
Yeah.
Yep.
Okay.
And up to and including termination, comma, referral for state and federal civil rights violations, comma, and or criminal prosecution.
I think we have that already.
all right.
Now, the other thing is that in the response to resistance policy, in describing what is excessive force, the policy itself refers to a standard for qualified immunity. The standard from this case called Graham versus Connor. And this is the Supreme Court said what a plaintiff has to show in order for somebody who's a police officer who's being sued, they have to show that the officer's actions were not objectively reasonable. And they say it can't be with the benefit of 20/20 hindsight. So this Supreme Court policy for civil liability, looking back on what has happened, provides police officers and municipalities with a means of avoiding liability based on this objectively reasonable standard. And so our point in the subcommittee was that our officers should be instructed not to engage in excessive force. And we don't want them to be distracted by this objectively reasonable standard. In other words, what we thought is that officers should be taught that they shouldn't engage in excessive force, and they use force only when it's appropriate and reasonable, because referring to this other standard is a way of watering down or confusing the issue, which is that you're only supposed to use that force which is reasonably necessary under the circumstances. And the same thing is true with respect to the defense of justification that is provided if an officer were to be charged in state court in New York State, because the law, Penal Law Section 3530, provides a justification defense for a police officer who believes an individual who he's attempting to arrest, they can use deadly physical force to stop such a person, to arrest such a person if they're resisting arrest, if they've committed a violent felony or certain other enumerated crimes like I think kidnapping and burglary. So that statute, which was enacted many years ago, provides a criminal defense, but we can have a policy that says that police officers should not be using deadly physical force to arrest somebody, that even if a police officer believes that person has committed a violent felony, unless the police officer believes that the use of deadly physical force is necessary to protect himself or other officers or members of the public from any kind of serious physical injury or worse. So just because there's a defense under that statute that might prevent an officer from being, say, indicted or charged with homicide, does not mean that officers should not be instructed to restrict the use of excessive force to only those circumstances where it is necessary under the circumstance. So that's why we suggested that.
Well, there's no circumstances that should require excessive force.
Well, if I misspoke, when I said the use of deadly physical force should be restricted to only those circumstances where an officer is justified in preventing death or serious physical injury to himself or to members of the public or other officers, for example, anyone. But the policy itself adheres in certain respects to this business of permitting someone to be deadly physical force to be imposed in circumstances where the officer believes that the person has committed a violent felony. It says, for example, this is in E, deadly physical force, on the page 4, E2. A police officer in the city of White Plains may use deadly physical force in effecting the arrest of a person that he reasonably believes has committed a felony, in which the use or threatened imminent use of deadly physical force has been used by the suspect. So, it permits police officers to kill somebody. When we say use deadly physical force, we mean kill somebody to effect the arrest of somebody when he reasonably believes that this person has committed a felony in which the use or threatened use of deadly force has been used by a suspect. And so that's different from the other, when it says A, reasonably believes it's necessary to prevent or terminate the use of or threatened imminent use of deadly physical force, which we all agree is necessary. But the business of may use deadly or may kill somebody to arrest somebody when the police officer believes that person has committed a felony in which the use or threatened imminent use has been used by the subject of deadly physical force. So you could have somebody who the police officer says, I reasonably believe this person threatened to kill his wife. He said, I'm going to kill you. And the person was like running away from the police officer. According to this policy, which I don't think you intend, the police officer may then draw his service arm, aim and fire and shoot that person dead.
No.
He reasonably believed that person has committed a felony in which he threatened the use of deadly physical force.
Based on the
Saying I'm going to kill you is not committing a felony.
I'm going to shoot you with a gun.
In and of itself.
And again, we didn't make that up, Richard. You know that comes from Article 35. It's reproduced word for word from Article 35. I know you have an issue with Article 35, but it's the penal, it's the New York State penal law. It is providing circumstances when what would normally be a crime are instances where deadly physical force may be used. That's part, it's just part of our policy. It's not a rubber stamp for cops to go and shoot people that, you know, when you say, well, he reasonably believed, well, that's where the objective reasonableness comes in. You know, he can say that, or she can say that, but they're gonna have to stand up to the articulable facts and what made them believe that. And you know, I'm not saying that, you know, well, we'll deal with the aftermath of this. You know, if he's wrong and somebody's dead, oh well. I'm not trying to trivialize it, but there's a lot more to it than the way you're making it out to be. And again, and I've said this many times, you know, there's the policy, and then there is the policy in action. And what are we doing? How are we training? What are we telling our officers? It's certainly not what you're suggesting, that this allows an officer, and they're not left to their own interpretation of it. It's not a one-time, here's the law, learn it and fend for yourself. Train for this. So, you know, this is where one of my contentions is. You don't want us to use Supreme Court law. You don't want us to use Article 35 to guide our procedures and policies. This is some of the areas where I'm concerned that recommendations are going to be made that are just not going to be workable. And I don't want to, I'm not trying to be the person that just sits back and just says, I'm not doing that. I want to come to some reasonable understanding of our policies and procedures and make relevant change. So that's where some of, well, that's where all of my issues come from, you know, and I just don't understand that you know, you're saying that Graham versus O'Connor, which really talks all about law enforcement actions and what they're being held to, and you're talking about civil, it's a civil thing, but there's criminal penalty, there is certainly stiff penalties for it. So to say that we shouldn't use that as a guideline when an officer could be sent to prison for forever is to me, I don't understand that. It's part of our training that they know the law. We need to have them understand the ramifications of federal law, of state law, and our local policies. And I think we do a very good job of that. Again,
So you think that if the policy of the state, if the law of the state of New York is that an individual police officer can be justified in using deadly physical force if he reasonably believes that a person has committed a violent felony offense, and that because that's a justification defense, if the officer was charged, that our officer should be saying, well, you're therefore permitted, if you reasonably believe that that individual's committed a violent felony, you may shoot him dead.
no.
Well, that's
Isn't it to prevent, but isn't it to prevent flight?
to effect an arrest.
Or no, but it should be to prevent flight. So in other words, you can use deadly force against someone who's just committed a felony if you think he's about to flee.
But we can't, that's not accurate either.
Really?
Not any felony.
That sounds a little
No, not any
wrong.
felony, but any felony involving a weapon or the use of deadly force.
Yeah, it's broader than that. If you look at penal law section 3530, it provides quite a broad defense of justification, which is sort of like self-defense, that the DA has to prove beyond a reasonable doubt that the person was not justified. Just like they would have to prove self-defense was not.
Richard and panel, I would just say that, you know, I know you're talking about, there's this word justification and they're justified. So what I do think that our response to resistance policy talks about is it also must be necessary. And that's where our policy comes into play, because you may be justified under state law, but it also must be necessary. And that's where our policy comes in. You know, if you know, under a broad set of circumstances, may an officer be justified in using deadly physical force, but it may not be necessary. So that's where the line can be drawn. And you know, listen, our policy in several places, paragraph 2, that all members will not use unnecessary or excessive force on anyone while performing their responsibilities. Down at the bottom, the second to last paragraph, members of the department may use only that level of physical force necessary in the performance of their duties within the limits established by Article 35 in Graham v. O'Connor. I will admit that we teach to it, we've taught to it forever since I've been here, but the Tennessee versus Garner, where the Supreme Court, you cannot shoot a unarmed fleeing felon. We teach to that. We have always taught to that. That's part of our, that is just what we've always taught to. So New York State law is, as Richard said, is a little bit broader, but the federal case which limits that is in effect. So, and then the final paragraph there, generally members may only use the required level of force that is objectively reasonable to bring an incident under control. We have prohibited force on page 2 so we're talking about all these prohibited things that and then unnecessary force defined, the last sentence, the use of indiscriminate force is prohibited. So I think that some of what you want in the totality of the document is there.
What about paragraph E2?
You know what? And of course, I can't find page 4. Hold on, maybe I just found it. I'm sorry.
Well, I can read it to you.
No, I'll read it myself. A police officer in citywide Plains may use deadly physical force in effecting the arrest of a person that he reasonably believes has committed a felony, in which the use or threatened imminent use of deadly physical force has been used by the suspect. And again, the word there is may. He's not mandated. It's in circumstances that dictate it, the officer may use deadly physical force. It's not pretty, but it's accurate. He may use deadly physical force in certain circumstances. Here's my example. A guy robs a bank with a gun and shoots somebody, right? He's not caught. We know who he is. 7 months later, a cop sees him walking down the street. Knows he hasn't been arrested for the crime yet. The version of deadly physical force, is that just officer justified in using deadly physical force to arrest that person? My answer is yes, to the extent that may that officer draw his weapon and give that person commands in order to bring him under arrest. I would say absolutely yes. If that guy runs away, absent any other circumstances, if that officer shoots that guy, that is not good, because he has no indication that the person is armed at that time. But the fact that they have committed a violent, I'm sorry, I want to read this, threatened imminent use, or he has used deadly physical force, that's the practical application of something like this. And it's not, I know you say killing of a person, but that's one aspect of the use of deadly physical force. I understand that the outcome may be death, but deadly physical force, it has a couple of different nuances there. Pulling your weapon out and pointing at somebody, giving them commands, is the use of deadly physical force. So that's where some of the training, that's where some of the application when we talk about this stuff goes into play. You know, my problem is that you have all read this maybe once or twice, and you're making your own determinations on what it means without the perspective of training and retraining and perspective and everything else. And then the outcome is that, you know, as horrible as it was, we've had one shooting in over 15 years, maybe 20 years.
Can I ask a question? A suspect hasn't been found guilty yet.
Right.
So to shoot a person that is believed to have committed a felony, that sounds wrong to me. I mean, he hasn't.
I have an active shooter run into the White Plains High School and shoot up the library and then run out with a gun. That suspect has not been charged.
Right, but it was seen. But he was caught in the act.
Has not been charged. He has not been charged. He has not been convicted.
All right.
But
So-
that would fall under paragraph 1 though, because if that shooter is, you know, presenting an imminent threat of
At the
deadly.
time.
Right.
If he stopped shooting and ran out of the school and ran towards the gym And you were the
Okay,
first
he's
officer and pulled up.
I mean, that's kind of different, but
No,
I
it's
see, I
not.
see what you're saying. I see, but it just sounds to me like
This is,
Look, if he still has a gun in his hand, he's still a threat,
if
obviously.
he has a gun in his hand, yes.
so this is the part of police work that is the most uncomfortable to talk about when you're not a police officer. Because I think as a private citizen myself and being a husband and father, I understand where everybody's coming from, not having the perspective of the training and how this is taught. But this is something, and maybe things need to change, but I want you to understand that this policy and procedure is not unique. I mean, and I'm not trying to say, hey, it is the way it is and everybody does it, so this is the way we do it. It's been, we have an accreditation program that either means something or it means nothing. And it's the New York State Department of Criminal Justice and the Metropolitan Police Training Center and all these other big agencies that have, their job is to provide us with guidelines and to make sure we are following accepted, for lack of a better way, industry standards. And this has been vetted over 30 years. Maybe if some of the recommendations were more, I don't know. I think that we're already in compliance with some of the recommendations. Again, the objectively reasonable thing to me is it's a valid part of it. I mean, to remove it to me does not make sense. I don't understand how having some and to teach officers that this is in a way it limits them. We don't teach it that, hey, don't worry about it because you'll be judged by a jury of your peers. This is, listen, just because you have to understand that your articulable facts have to be justified. Meaning you can't say, I feared for my life because they had a bat and they were 20 feet away. And that's how I felt. My objectively reasonable brain told me I was okay to use deadly physical force. Retain that you will be viewed by what another reasonable person was presented with at the time and determine whether your actions were reasonable under those circumstances. That's how we teach to it, not to give them leeway, but to focus on how Connor limits us, or at least guides us to be more limiting in what we do. And again, I'm telling you this, but this is what we teach. This is how we train. This is the culture of this department. So I just wanted this opportunity so you understand that when you make your recommendations. I'm not going to tell you not to make your recommendations, but it just, to me, it's a little frustrating that there's no perspective. You're reading it, and even when the wording is uncomfortable, there is legal reasoning behind it, and it's not unsound on its face. It is, I could read you the accreditation program, what it says and the reason behind it, and why it does what it does to, conceptually sound accreditation acknowledges the implementation of policies that are conceptually sound and operationally effective. I'm assuming that a lot of this stuff has been vetted by people way smarter than me over the years. I mean, it's been held up over the test of time. I understand your arguments and your interpretations. I just don't agree with all the interpretations of what you think this means.
So, just to clarify for me, Richard, I thought that the point that you were making is that White Plains could have an additional exception to this policy that states that White Plains officers will go above and beyond what is stated in 35.30?
Well, it's that what we are proposing is that our officers should not be taught to use deadly physical force, which my understanding, and I think is the general understanding based on the model policy that the state has, is that the definition is, I'm quoting here, physical force which under the circumstances in which it is used is readily capable of causing death or serious physical injury. So, and that's a definition that comes out of Penal Law Section 10, subdivision 11. So, that's my understanding, but our policy is, current policy is that police officers can use deadly physical force to effect an arrest when they believe a suspect has used or threatened the use of deadly physical force. And I just don't think that, our officers, even if they couldn't be indicted for it or couldn't be convicted of it, should be instructed not to do that. But on the other hand, policy number 1 under deadly physical force says, and we support this, that the police officer may use deadly physical force when he believes it's necessary to prevent or terminate the use or threatened imminent use of deadly physical force against him or a third party, or to prevent serious physical injury. So we're saying that stays. It's just this subsection here that permits, killing somebody, and that's what it means. You're talking when you're a police officer and you're pointing a gun at somebody and shooting at them, you're not trying to wound them. Okay, there has to be a justification for trying to kill that person, and even if they could present a defense, we think that officers should be, as a matter of policy, should be
Richard,
told not to do that.
Do you think all police officers should be held to that standard, or just White Plains Police?
Oh, I think all police officers, but we're only dealing with White Plains Police.
Why wouldn't we want to lobby the legislature to change the penal law?
I'd be very happy to do that, but this is not what we're doing here. What we're doing here is recommending a change to policy for the city of White Plains.
Why would we not use what's in the penal law? Why would the penal law of the state of New York, which is valid for everybody else, not have some applicability to the White Plains Police Department? And what you're saying is that we're using that as the sole guideline of when we use deadly physical force. I'm trying to tell you that's not accurate. But you want me to change something that is based right out of law. We didn't make that up. It's right out of the penal law. So maybe we change. Well,
I think maybe that you are saying, Chief, that we cannot have a policy which is more restrictive than what the penal law provides.
We do have a policy. That's what I'm telling you, that is more restrictive. When I say that it, when the areas where I was just talking about, where now of course I can't find it, where the when we talk about it must be necessary, that's where we come into play. So as I said before, you may be justified in using physical force, anybody under Article 35. It's not just about cops, but there are cutouts for peace officers and police officers. But just because you may be justified under the penal law may not mean that use of force was necessary under our guidelines and under our review, and that way, and in that case, you may be subject to some type of police discipline. That's the way this has always been interpreted. That's the way this has always been, based on a lot of the stuff that I read. That level of force necessary. So to me, the necessary part is certainly different from the justified part.
Well, the necessary part or the justified part or necessary, those words don't appear in E2.
We are reproducing the penal law, giving a basic guideline for what an officer may do based on what the penal law says. Then it is enhanced by the overall body of the response to resistance policy. So again, it may be a matter of the setup that is not, that you don't like, or the I don't know, but all I'm telling you is that if you want us to take that out of there, it's going, just remove it. it's going to be an issue because I think that there's relevance there. And I don't want to go into this, so the end part of this, I would like to, go into this, or at least with an understanding. If you're gonna make the recommendation, make it. At some point, maybe there has to be some understanding that we have raised some concerns about some of these recommendations. Because if it comes down the line and we can't or won't, or we get some other type of city legal advice that it's not in the city and the department's best interest, or it's not proper procedure to change certain things, and we don't do it, I don't want to be said that, well, we lied, or we agreed to something we knew we wouldn't do. I mean,
Can we recommend further review and possible support of changing it? The penal law?
Janice, support it. If you guys want to petition to change the penal law, that's fine. I mean, my understanding, it's already been done, the petitioning part anyway.
Okay. So
So
can we recommend that we further review this?
Why would we do that? I mean,
Okay,
we have
because-
a recommendation that the subcommittee made. We understand that the police department has some objections to it. And those objections can be raised with the committee as a whole, with the city council, with the mayor's office, or anybody else that they want. This committee does not enact anything. Certainly our subcommittee doesn't, but even the committee as a whole doesn't. There's no enacting part of this at all. This is either going to be enacted by the city council, or it will not have any effect. So, we're not enacting anything.
So what do you want to say in the recommendation then?
Sorry. I think what we had in the recommendation, we had the recommendation that was sent around.
Well, it says that in the recommendation, it says officers should also be taught that the use of excessive force by officers can and has been investigated by federal law enforcement.
Yeah, but that's
And
not,
punished
that's
as-
already included. That's
already included. All right. The reference to objectively reasonable, is that what you're referring to? Is a reference to the standard in
Okay, so
Graham?
look at paragraph 2 in the recommendations that the committee made. There was, under duty to intervene, the policy
Mhm.
should be, quote, any member, an officer observing another member using excessive force shall, when in a position to do so, safely intercede, right? Because there was the difference there about, what are the obligation, and above it says that we thought that officers should be instructed not to engage in excessive force. I mean, I don't have a problem with officers being taught what Graham versus Connor says, as long as they're also taught about what Tennessee versus Garner says. But that is not necessarily what our policy should be. In other words, what you want to do is teach police officers that they may be civilly liable under certain circumstances. That does not have to be the policy. So that's why we have here, the policy should call for the reporting of excessive force, and also that the part about under E2, we think that's wrong. We think an officer is not justified
state
in
law.
using deadly physical
State law. How
force.
can you say it's wrong? It's state law. That's my only contention.
Yeah, we say it's wrong.
Yeah,
because
that's
it's the
problematic.
policy of the city of White Plains is what we're saying.
But you're
There's
not.
a statute that provides a defense for an officer who does it, but that doesn't mean that it should be the policy of the city.
You make it seem like it's the sole policy guiding tenet in this whole document, and that's where my issue is that you want to take the specific parts of it, Richard, and say this is no good, this is no good, instead of taking the document as a whole, and you're making assumptions about our training and our culture here that you're just assuming that we're performing to the lowest understanding of this stuff, and that's somewhat unfair without having the perspective. But
I-
it's also, as I said, it's Article 35 is part of our response to resistance. There's no way it can't be. Sub 2 is right out of the penal law. And based on all the other areas of our response to resistance, where we talk about only necessary force, the department may use only that level of force necessary, and everything else combined with uh, uh, um, Tennessee versus Garner and Graham versus O'Connor and Article 35 and all this other stuff gives us the totality of how we train our officers and what we expect of them. It's not a document that gets thrown at them on day one and they learn or don't learn it on their own. So to say
Okay.
that is wrong, I think is I understand what you're saying. You don't like the fact that that's in our policy, but that doesn't make it invalid as part of our policy. It's part of Article 35 in the penal law of the state of New York. To cite that or to use the exact wording in our policy to me to say that we shouldn't do that, I don't understand that. And you're not.
Why
you're
don't
not
you
giving it
understand that we think it's
Well,
wrong? Why don't you
I-
understand that?
I think the subcommittee at this point should make the recommendation.
Hold on, yeah, just a second, everybody. Karen, and you have to help me, and Janice, you have to help me. Do we have to agree on everything that we put in our statement to the governor? Or are these just recommendations that we may make? And at times they may be in opposition with what is current and standard, but yeah, they're our current recommendations. Not that they are to be put into law or into practice, but they're just our point of view. Can we make that judgment?
Well,
Just
I
that-
think
just
that the
that it's something to write.
committee can make a recommendation. And if there is serious disagreement about the recommendation, then it should be noted in the report.
And I think that's a good thing.
We've been,
think we're supposed
we've
to
been
have a
lucky in that the other subcommittee recommendations have not, we've not experienced that. But if there is a recommendation that the subcommittee wishes to make, we can put it in here, but I would strongly advocate that we note the objection and the reasons for the objection, or the reasons for the disagreement over the objection, by the police department.
Can I
so-
make a suggestion here? Now, Chief, you mentioned that after all this, it's your intention to kind of like rework your policies and procedures book, if I heard you right.
Yes.
Is that right?
Yes, sir.
He started already. He's assigned us to do some work.
So what if we put in our recommendations that, one of our recommendations is that, the policies and procedures manual for the city of White Plains be, I don't know, be revised and amended with all of these principles that we, are recommending in mind. You follow? So kind of saying that we intend, or that you intend to amend your policies and procedures, keeping all of these recommendations in mind. I mean, we're not tasked here to rewrite the whole policies and procedures manual. But
Yeah.
we can recommend that it be done at a future date.
I
I don't
mean, I think that would be I don't necessarily disagree with that. I think, the intention that we're trying to get here is that, we will make every effort to implement the recommendations that are made. Absolutely. I just, some of the things you said, I'm not sure I understand, or I don't want to ever, put myself into a corner. But I think that, yeah, I mean, I do think that that's my intention. And again, I don't know if Richard is here to hear this. I don't mean to be contentious. This is really our first opportunity to hear our perspective on the policy and procedures thing. We've had very little opportunity to have our perspective on this. So, this is coming right before they're going to be put out there. I just wanted to make sure that, it was understood. I don't mean to be contentious with anybody. I mean, I do love a good debate, I just want the police perspective to be heard, and then the subcommittee obviously is still there to make its own recommendations. I just want to, for the benefit of the police department, make sure I have gotten our point across as pertains to these recommendations. So I understand there's going to be plenty of things, not only in this subcommittee, but others that
Right.
I may not outright agree with. But that's not my call. You know,
Well, I think part of the problem is, we're looking at like this thing word for word. Some of this stuff, I have to tell you, is a little bit ambiguous. And some of it is awkwardly phrased and used and repetitive. So, but obviously that just goes to like style and to maybe reworking it down the road. But I think that's where some of the problems come in because they are ambiguous and you're reading it one way, I'm reading it another way, Richard's reading it another way, and so on. And I always think that it's, the simpler, the better. And the more straightforward the wording, the better. So, I mean, that would be my recommendation, is just to kind of rework this somehow. I don't think it's our job right now to rewrite this whole, policies and procedures manual.
I mean, I think your recommendations, the way they are pointed. I understand everybody's, when you're reading something and you're getting a take on what it means, and then you made your recommendations. I just wanted the police department perspective, whether that changes anybody's mind or offers you any valid perspective or not. I don't know. I just, as I said, one of my fears is that, there may be some stuff that down the road we can't do. And I just want to be able to express that we have these issues and some of these may be tough, that we think they're not because we don't want to, but we think they're valid, and again, I know what you're saying, but, make them simpler. Use of force it's not a simple thing. And we try to be comprehensive. We try to get a lot in there. Policy is a policy. It's a guide. It's a guiding policy. I mean, it's how you train and what you do in the street, which really shows how effective it is. But as I said, I don't know.
Yeah, so as we kind of wrap this up, I believe this is towards the end of it. We are coming up on 9 o'clock, 2 hours worth of this. I think that we've exhausted, and Karen and Janet, you tell me if we're at the end of our conversation just about. But what I understand, I think that we should keep our recommendation, but alongside that recommendation, Chief, you should explain as best in detail as you can why you feel that does not meet the current your current understanding, current need of what can be done or what should be done by the department.
And I will do that. I would just maybe some feedback other than from Richard. I understand Richard's point of view. I understand his argument. Based on mostly what me and Richard have talked about, what is anybody else's take on it? I mean, does any of what I've been trying to explain make any bit of sense, even though you may not agree or understand it wholeheartedly, that the policy and the bigger policy on itself deals with a lot of the questions that your recommendations are bringing up, that's part of my thing. We believe that most of this is already handled and then backed up by state agencies and probably federal. We don't look at federal stuff, but there's probably federal accreditation that would look at this policy and pass it. I'm not saying just because they're doing it, you should leave it alone, but I mean, it doesn't mean anything. And if not, then the recommendations are what the recommendations are. I'm okay with that. We'll deal with it. I just want to know if there's any further perspective than what's been previously put down as a recommendation.
Look, I think if we're talking about paragraph 2 or subparagraph 2,
I'm just talking about pretty much what we've talked about some of the
everything.
I mean, well, I mean, if that's that is a seems to be a bone of contention. It's New York.
Well, it's right. It is. And maybe by rewording it a little bit, and I understand what you said about, that somebody robbed a bank and you see him on the street like the next day. Maybe this could be a little bit clearer if you say a police officer may use deadly force in effecting the arrest of a person that he reasonably believes has committed a felony in which the use of deadly force has been used. So that, I mean, and this is just a minor thing, I guess, maybe for me, it's kind of not, but which the use, I don't think you need that or threatened imminent use. Because if it's already been used, it's not threatened or imminent.
Well, this would be something that wasn't used, but was imminently threatened. And the example came up of, I'm gonna shoot you with a gun. Now, does a person have a gun? They have access to a gun? Are they in a hospital? Are they in jail? Those things have perspective. Or does the person have access to a gun? Do we know they have a gun? That threatened imminent use, I'm going to shoot you with a gun, and we know you have a gun, makes it different. So that's where, as I said, nuances or different lines are put into effect. Again, this is our training. You can't put training in procedure and policy. You can't put everything we train to. So that's why I'm trying to get you to say that, the things that are said here, you apply the training and the overall policy in the different areas that we bring it all together, and it is a valid policy. It's a pretty good policy that shows our officers how serious this is, and gives them good, clear guidelines of what to do and what not to do. And I can only tell you that if I hate to say the proof is in the pudding. We're not a department that uses deadly physical force in any, we use it, but it's minimal, comparatively speaking. I mean, it's minimal. It justify use of deadly physical. I mean, to me, a little bit of the proof it has to be taken into consideration is what's the end result here. If we had a policy, but we were shooting people or we're using deadly physical force, and the policy means nothing. But if the policy is apparently sound, when you take it in context with everything we teach to and everything we try to do with our officers, and the results are there, then this is where my issue is. You're asking us to take a part of this out, which is directly out of the penal law. And if that's the recommendation, I'm not trying to tell you anything other than that, then it would be something that we would say that's going to be a little problematic. I mean that's kind of it. I don't want to beat this to death. I think we set our piece to hopefully give some understanding, and the committee's going to make its recommendation. So. Any awkward
Well, I think it's a very spirited piece of our conversation, I think, and that's why there's just a little to no conversation behind it. I do have some understanding of where you're coming from based on some actual activity that we've seen happen, but I don't want to get into it, but I do feel, however, that we're not only looking at this issue based on what happens in White Plains, Chief, and as I said to you before many times, what happens every place else with police department is White Plains. So whenever it happens someplace else, our consideration is this is White Plains also, because when you say police is everywhere for us, civilians. So our sensitivity level is not just that White Plains may not have this happening and hasn't happened, has not had it happen over 20 years, but because it's happened in other places, we're sensitive to, and I know as an African American, we're tremendously sensitive to the fact that this has happened in other places, and it feels like it's every place for us. So when we come to consider this issue, it becomes an issue of we're not just qualifying White Plains. And on top of that, I thought that the point that Richard was making is that can we be an exception in White Plains in stipulating that this is something that we'd like to make special note of for our police department, which makes us different than everybody else. So that's why I thought that the spirit of this was coming from.
I would say this, that, you know, if somebody said, you want to take on the budget, you know, my concern is that part of this policy is a tool for officers to use. And part of the policy has to do with safety. So if it was to take something away that's in the penal law that's provided to every other person in the state of New York, there would have to be some consideration there. So if you mention it from the Senate, can we be the department that does it differently? I would say many times we are. So from that standpoint, I just can't say on a Zoom that the recommendation is a valid recommendation, you know, here today. You know, it would just like the other thing where I have reference material that says under these circumstances this is valid. You know, the penal law and taken in with the whole seems to be a valid policy. But I'm not saying we can look at it further. I wouldn't want to put anything in there that would be overall detrimental or overly limiting to how we operate in White Plains. That's kind of all I'm saying from this. So if you want to say that, you know, maybe what Marie said, but you know, it gets a little sketchy when we say, oh, well, you know, we'll take it under consideration. You know, you have it from me that we will look at it closely. I just I don't know what else to say.
So I think Chief, if I could interrupt, that what I will do is add in some of these remaining recommendations that we had held off on including in the last draft. As the committee wishes them to be added in, but also because there is some serious disagreement over these, I feel it's only right that we note that as well in the report. And so I will attempt to draft up something that incorporates not only the committee's recommendations, but the concerns around some of those recommendations that have been noted. I think in this case, because of the level of debate here, it's only right that we note that there's, you know, that these are not, that there's some difference of opinion. So I'll note that in the report.
I don't think there's serious disagreement here. I think we're disagreeing over some small things, maybe the wording and whatnot. I think we all agree that, you know, the police need to use force when they need to use force. It's just kind of in the way that we say it. I'm speaking for myself. I'm not speaking for Richard. I don't know where he went, but
I didn't go in.
Richard, are you there?
Everything you said.
Okay. I don't think we have serious disagreements. I think we're disagreeing over, you know, relatively minor things, considering everything that's in this manual. You know, we're disagreeing over, you know, maybe 2 or 3 things. So I don't call that serious disagreements. Well, that's just my take.
Okay.
Well, okay. I think what we recommended was that even though Penal Law Section 3530 permits a police officer to use deadly physical force to effect the arrest or prevent the escape from custody or in self-defense or in defense of a third person, when the officer reasonably believes that the offense committed was a felony or an attempt to commit a felony involving the use or attempted or threatened imminent use of physical force against that person. That's what that statute says. Or it also includes kidnapping, arson, escape, burglary in the first degree, some other things. So the statute gives a very broad defense to police officers who use deadly physical force to effect an arrest of a person that they reasonably believes has committed a felony. What the committee thinks, and I'm speaking based on what we said many times over the course of many meetings, is that we do not think that in our city, that police officers should be judge, jury, and executioner in effecting the arrest of a person under those circumstances. That they shouldn't use deadly physical force to kill somebody to effect their arrest, unless that there, as we said, some necessary defense of the police officer or people in the vicinity, which is what we said. So the penal law does permit a defense of those things, but what our committee was recommending, and of course the committee could change its mind, was that the sub 2 policy that we referred to before under deadly physical force, we think is wrong for our city. It may be in compliance with the justification defense in the penal law, but we do not think that police officers should be permitted to use deadly physical force, even if they reasonably think somebody has committed a felony involving the use or threatened imminent use of deadly physical force. We believe that more is required before a police officer in the city of White Plains, uses deadly physical force, such as is necessary to prevent or terminate the use of or threatened imminent deadly use of deadly physical force, which is sub 1. So that's what we said. I understand that Chief Castelli and Captain Spencer want to maintain the right of police officers to use deadly physical force under those circumstances. I think we have a disagreement with respect to that, and that's what we've discussed tonight.
Thank you, Richard. So Karen, I think you're right. So have the recommendation as written, and then we'll add a blurb as to why we disagree.
Have we come to the end of our conversation?
Hope so.
Anything else, Chief?
No, I think that sums it up. As I said, I just, I think that if we had some of these conversations earlier on, maybe we wouldn't be here toward the end and having it that much contentious again, which not anybody's intention, I'm sure. I just think that maybe a couple of us are very adamant about how we see things. So that's fair enough. So yeah, I just appreciate that we have this so we could get our perspective out, and we will do our best with what the recommendations of the committee are.
Thank you. Anything else, Captain Spencer?
No, I just concur with the chief, and I appreciate everyone's passion and commitment to the subcommittee.
I have a question for Karen. What's the next step after, submitting this?
So thank you, Marie. The next step is that we need to finalize this draft report really as soon as possible, and then put it out for public comment. The governor's executive order requires that we put the document out for public comment, which we would like to do for about 10 days. And then we'll assess what comments we get and assess if any further changes to the report are needed. And then after that, the report can be finalized, and then it would be sent to the Common Council and the mayor. So just sort of April 1st is the deadline by which it has to be up to the state, and working back from there, we will miss the March meeting of the Common Council, the regular stated meeting, which is the first Monday of every month. So I think that's actually March 1st. For March is the first Monday. So I think as a practical matter, we're not going to make the March 1st meeting, but I've spoken to the Corporation Council about scheduling a special meeting in order for the council to be able to receive the document and consider it. So there is not a lot of time. It needs to be, even with that little reprieve of not making the March 1st deadline, it needs to be finalized by early next week and put out to the public as soon as possible. So that's my next step.
Okay. Thank you, Karen.
Mhm.
So going around the room, Janice, is there anything else that you want to add or comment on tonight?
So Karen, do I understand that you're just going to leave the recommendations that we didn't go over, that we did have some questions about? You're just going to put them in the report? I thought there was something something on maybe body cameras. Did we have an issue with that?
I think that at the last meeting, and Marie, you tell me if you feel differently about it, but at the last meeting, you seemed to be comfortable with the body camera recommendations, that they pretty much reflected what you had wrote up.
Yeah, I
I did
think
have a question. Yeah, okay.
What about Marlene?
And Merlene was
I
the one
you
that
didn't
I
let
had
me
a
get there.
question about.
Yeah.
We had some questions about her recommendations though, right?
Correct.
That are
I only saw one.
There was one recommendation, Merlene, that we were asking for more information on. So this was related to strip search.
It was the one that
Right.
I have it.
You had said revise should follow federal and state language. But it
So-
wasn't clear to us what particular language you were referencing. And so if you could get us specific language,
No problem.
okay, that would be great. And then there was another one also regarding strip search, where you had raised concerns about a
In
couple
demeanor.
of the criteria, right? Arrestee's appearance and demeanor, circumstances surrounding the arrestee's criminal record, particularly past violent crimes and narcotics offenses. And then I had written in the comments that they had some, reasons why they thought these were legitimate criteria on which a basis of reasonable suspicion may be established, and they'd like the opportunity to discuss it further. So I don't know if, I know we've already been at this a couple of hours, but this is our opportunity to get through any outstanding questions. So I don't know if Chief or Captain Spencer, you wanted to speak to that. This is in the strip search and body cavity searches policy,
Yep.
section 4A.
But I don't have it in front of me, but I know that one of the things was appearance and demeanor. And that many of those things should be stricken. Again, the perspective here is that it's their appearance and demeanor after the arrest. Using a drug arrest as an example, that if they seem to be clenching their muscles, leaning against the wall, not wanting to come off. There are, if they don't want to take an outer layer of clothing off. So that's the perspective about when we would want to, believing that they may be secreting drugs on their person. So part of the reason is that, it is potential evidence of the crime. The secondary part is that we don't want them going into a cell with contraband, because we are responsible for it. So that's part of that. So it was appearance and demeanor. I hope that gives some context, not anything other, not about just their general demeanor and physical appearance, but as related to if they may or may not be secreting a contraband. It could be a weapon also, something along those lines that may not be able to be found during and even a more thorough search at headquarters subsequent to arrest by searching the outer garments. Anything that we believe is inside any part of the body, we require a body cavity search warrant. And any strip search that's done has to be approved by a boss. And again, the officer has to go to the boss and say, this is why I want to do a strip search, and give the reasons why they think it's reasonable to do that. What were the other besides appearance and demeanor? What was some of the Marlene?
So I can read you the actual section. It says, no arrested person will be strip searched, especially persons arrested for traffic violations and misdemeanors, unless the arresting officer has reasonable suspicion to believe that the prisoner is concealing contraband or weapons. Reasonable suspicion may be based upon, but is not limited to the following. And then the bullets are the nature of the offense, the arrestee's appearance and demeanor, the circumstances surrounding the arrest, the arrestee's criminal record, particularly past violent crimes and narcotics offenses, the discovery of evidence, weapons, narcotics or contraband at a stage prior to the arrest, detection of suspicious objects beneath the suspect's clothing, a positive reading on the magnetometer, metal detector, after a thorough search of the clothing.
Okay, so.
But Marlene only had issue with 2 or 3 of those.
That's correct. She had raised the arrestee's appearance and demeanor, the circumstances surrounding the arrest, and the arrestee's criminal record, particularly past violent crimes and narcotics offenses.
So, I mean, this is some of the articulable things that would give rise to why an officer would want to do it. So, again, if you had one of these, if an officer said, I want to do a strip search because they bought drugs, absent any other thing, I don't know of a boss that would authorize that. That's not reasonable suspicion that they are secreting something. But hiding drugs, clenching their legs and their buttocks, refusing to remove outer garments. They've had prior arrests where it is found that they have secreted contraband or drugs, things like that would add to all that. The criminal record has to do with their criminal record, what they arrested for, and the circumstances of their arrest. Meaning, have they hid weapons before? Have they hidden drugs before? Have they done those types of things? So these are just instances that an officer would have to, again, using the word articulate to a boss to say, I believe a search warrant, a strip search is warranted in these circumstances. And then the boss would make the decision on whether there were good grounds to allow them. Secondarily, just so you understand, we take them into a separate room. We afford every manner of dignity that we possibly can. And I know our policy allows strip searches out on the street in very limited extreme circumstances, but I don't know if I've ever found one of those where if we felt the need to do it, it couldn't be done in headquarters in a more discreet manner. So I don't know if that answers anything or if you have more questions. I think that's the perspective on what the policy is saying.
Okay, so that did answer questions, especially for bullets 2 and 3, considering they don't mention narcotics or anything like that. So it was with the assumption that literally on arrestee's appearance and demeanor, that they could be strip searched.
No, it's after arrest, and if like for example, if in headquarters that person is hunched over and clenched up as if they were trying to hold something in place underneath their clothes, that speaks to appearance and demeanor. Not necessarily how one looks or height or weight or color or ethnicity. It's their physical, what their behavior, their appearance and demeanor. Marlene.
It's really just their demeanor then, not their, I mean, you could say that just by saying demeanor instead of appearance.
Okay.
I mean, I'm sure there are circumstances where the appearance applies that I don't have a good example right now. The demeanor is how they're acting, and appearance is how they look, combining those two together. Meaning appearance could be that, they do have something,
Well, if they appear to be like
and
under,
you can't determine what it is. And,
Yeah.
Again, that's what the appearance part would be to.
okay.
but
Well,
if
somebody
you-
appears to be under the influence of, of drugs or alcohol.
No, I don't mean that. No, I don't. That's not what I mean. I mean the physical appearance, the clothing, the way their clothing looks. Sometimes, as I said, there's a reason why a pants may be down lower or something. Why something may be tucked in. That's what we're talking about. The fact that somebody appears to be drunk or intoxicated that's never, a reason. There has to be other reasons why. Just like it says, traffic stop, unless you can, there's almost no traffic stop that I think that would, or traffic arrest that would dictate a strip search. So I hope that offers some clarification. I don't know what appearance and demeanor means.
It does offer clarification. It's just that as someone, just as a general citizen reading this, it can come off as biased, especially with everything that's been going on. So I just wanted you to also understand why it was pointed out.
So, physical appearance probably doesn't solve that problem either, because then there could be, what do you mean by physical appearance? I think this is one of those things that, as I said, we have it in our policy, and it's the teaching of it that gives it meaning. You know what I mean? And again, this might, I agree that you reading this and you'd say, what do you mean by appearance and demeanor? What does that have to do with it? The perspective of the police officer making the arrest, what the arrest is, and I think we do go into certain signs that may give rise to reasons for a strip search. So that all feeds into appearance and demeanor.
Okay.
But if there's a wording that makes it that can be put out there that says the same thing, and if you believe minimizes the misunderstanding of that this is about some type of demographic or racial thing, I'm all for the help with the wording on it. If there's something that can replace appearance and demeanor that says the same thing, but is a lot more objective, I guess, if the word is, then by all means.
One of the words that was used was behavior. I think that can be helpful. So like the example that you're giving with the person clenching, they're bent over. So I think behavior can be helpful. I don't know what can necessarily replace appearance.
I get it. I think that you're reading it as, or someone may read it as appearance meaning race or ethnicity. That's not what it means. That's not what it means. And this, again, this policy is for police officers that are being trained, not for the civilian or the lay person on the street.
Yeah, but we're trying to make it so that the people on the street can see it. If we put it on websites, so they will misunderstand that, because when I read the word appearance, I'm thinking race, height, size. I'm not trained to know what you mean by that. So I think We do need some clarity in that.
But Janice, this procedure is the procedure for the police to follow in police terms. It's
Okay.
not necessarily
So
in,
can we clear that up? Can we add to that, some way that this is for the police, not necessarily the appearance of race? Can we add that in there? That, put a little in parentheses, not including race, size, can we add that? Because I think the average person looking at it is looking at it and thinking race. So if we could put not including race, not including size or whatever. So that, can we add something like that?
I don't want to go down the road where we have to, theoretically, the book is the procedure is an objective procedure, and we train toward the objectivity that that race and demographics and other things don't come into play here. So if we did it there, we'd have to pick out hundreds of other places where we may have to make that distinction. I think my opinion is that if we clarify the wording to make it less misinterpretation by anybody, that would be a better way to go. So, if we take away demeanor, we could put, maybe, physical behavior, what I mean? So that gives a little bit clearer understanding that the physical way you're behaving, because even behavior I don't like, because behavior tends to mislead people that if you're behaving, meaning if you're acting appropriately, it shouldn't be a problem. But somebody could be very, very, very passive, but not cooperative. You know what I mean when it comes to behavior. But I would just, my recommendation or my part of this would be to clear up the wording so that way it's less likely to be interpreted than to have to spell out that this does not mean something. You know what I mean? Because then we're going down that road where we would have to do that in a lot of areas. And again, the book, it's helpful that the book would be better understood by lay people, but it is intended to be a guide for police officers. And they do understand what that means. There's no, room for interpretation. But again, that's just my take on this.
So maybe, Chief, as one of those overall recommendations that I'd love to make about about the policies book and procedures book in general, is that there's some, if it's not already there, it should be specified in general rule that this document is intended for the use by White Plains Police Department officers.
Well, I think that goes without saying.
Yeah, but if we're saying that now, the book may be, just from the point that I hear that both Karen and Marlene are making, it makes sense that anyone interpreting this book needs to take into consideration that this is a document that's written and made for these individuals. And it may go without saying, but it should be stated too, in fact.
But that's not comforting. That doesn't make you feel better that the word appearance doesn't really, is meant for the police. We still want to know what that means.
Oh, absolutely. But take into consideration that, as the chief is saying, that you could go through hundreds of places in this document and it will not be clear to a layman or civilian. A lot of places in any of the policies that exist that cause you to say, wait a minute, does that mean X or does it mean Y? And
how about,
How about after the word appearance, you put in parentheses, for example, if he appears like he's hiding something or something along those lines.
I was just going to recommend, so something along the lines of behavior or actions that may indicate, hiding of contraband on the body, something.
Concealment, yeah, concealment of contraband weapons.
Concealment of contraband. So, what did I just say? I can't remember anymore.
Behavior
or-
or
or
actions that may
actions that-
indicate concealment of contraband
Or weapons.
or weapons. Marlene,
Make it
what do you
clearer.
think?
Yeah, that sounds good to me.
Does that
Yeah, so
clarify it?
definitely-
Yeah,
Yeah, that clears it up a lot better.
okay.
Because I understand that this policy is for the police, but considering that this is going to also be read by the general public, having it be clear, because honestly, as a Black woman reading this, I'm thinking, okay, so if my brother walks down the streets in baggy jeans, that's appearance and demeanor. You know what I mean? So I think
Mhm.
No, but
the more we could clear it up, the better it is.
and again, Marlene, just so you understand, this certainly is after a post arrest. So when somebody's arrested and in jail, there may be a need to, they get searched incident to arrest, and that is a kind of thorough search of their clothing and body. But this is just a circumstance where, based on X amount of articulable facts, that we may need to do a strip search to make sure there's no more contraband on it. So it's not a matter of, somebody walking down the street. I mean, we apply a strip search to them just because their appearance and the way they look, or even if they have a criminal record. There has to be an arrest in place, and it's an arrestable offense for which we would bring them into headquarters, and where they would be subject to search incident to arrest. So it wouldn't be, as I said, let's say your brother and he's driving a car and he gets a ticket and his appearance is such that we would want to do a strip search. You know what I mean? It doesn't. I hope it doesn't flow that way. I mean, I know it doesn't, but I hope the wording of that doesn't give the impression that it flows that way. But
I think that the language that we just discussed is a nice clarification of what you're really getting at here.
Mhm.
And we can easily include that.
I agree.
Okay.
For the part about the no arrested person will be strip searched and so on, which is the first part of the strip search section 2, that was language that was brought up by Richard. I don't know if he could explain it for us in regards to it should follow federal and state language.
Okay.
Oh, there he is. So it's strip search and body cavity, section 2, and section 4A, number 1. So there was a concern
Section
about whether or not it
2.
followed federal and state language.
Yeah, your voice faded out there. Is there a particular part of the strip search policy that we should be looking at? Because I can call it up on my computer.
So what I have is section 2,
All right.
and then
And particularly,
it was the part about no arrested person will be strip searched, especially persons arrested for traffic violations and misdemeanors, unless the arresting officer has reasonable suspicion to believe that the prisoner is concealing contraband or weapons. Reasonable suspicion may be based upon, but is not limited to the following. So it's that whole section that you have brought up, whether or not it followed federal and state language.
Yeah. I want to look back and see what we wrote about that, because it's been a while. Let me see if I can find it. Let's see. Here is the email. Oh, I think that I had a quote from this case called Mother Cell from 2010. And what they said is visual cavity inspections cannot be routinely undertaken as incident to all drug arrests or permitted under a police department's blanket policy that subjects persons suspected of certain crimes to these procedures. There must be particular, individualized facts known to the police that justify subjecting an arrestee to these procedures. It says our precedent on this point is unequivocal. The police are required to have specific and articulable facts, which, along with any logical deductions, reasonably prompted the intrusion. Although they are allowed to draw on their own experience and specialized training to make inferences from and deductions about the cumulative information available to them that might elude an untrained person. So the point here is that what they're saying to conduct a cavity inspection, it's called, there have to be particular individualized facts that justify subjecting the person to this kind of body cavity search.
I think in New York, a body cavity search requires a warrant. We cannot do a body cavity search.
Yep, we agree with that.
Yeah. So that's I do think our policy reflects what Richard read, but that's my opinion.
Yeah. So these, they're talking about visual cavity inspections here. This is where somebody is suspected of hiding contraband, usually drugs, in a body cavity, which could be any of the ones you can imagine. So I don't know. Does that answer the question, Marlene?
I'm not 100% sure.
Okay.
Berlin, in the
So section
recommendation,
4A.
yeah,
Yes.
4A number
4A
5,
number-
second bullet, which is by the fewest number of personnel necessary and only by those of the same sex. Or, well, the header is when properly authorized strip searches may be conducted only in the following manner. By the fewest number of personnel necessary and only by those of the same sex in the event of transgender, intersex, or
Karen, what you're reading, that one?
Yeah, that's what you referenced?
No. According to the notes that you sent me, that was just a citation correction that needs to be the one that you're reading right now. The one that was corrected was
Okay.
4A number 1.
4A number 1. Got it. My apologies.
No worries.
4A number 1, which was right, the same section that we were talking about earlier.
Mhm.
Right. So but that relates only to strip searches and not to body cavity searches.
Yeah, well, the case says that a post-arrest strip search must be based upon reasonable suspicion that an arrestee is hiding contraband beneath his or her clothing, and that a search involving, that goes on to talk about body cavities. So there has to be reasonable suspicion that they're hiding contraband underneath their clothing. I mean, that's all it says about that.
And that's what our policy says, correct?
That's what our policy says. No arrested person will be strip searched unless the arresting officer has reasonable suspicion to believe that the prisoner is concealing contraband or weapons.
Yeah.
Oh, is that okay?
Okay, so then that can be taken out then.
Okay.
Yeah, it does have a thing here about body cavity searches. And it says that you need a search warrant, I guess.
Right.
But as far as strip searches, there, I mean, I'm reading from a Court of Appeals. The Court of Appeals is the highest court of the state of New York. And, what it says about post-arrest strip searches, is just that they have to be based on reasonable suspicion that the person is hiding contraband underneath their clothing. But it's very different if you want to do a visual inspection of the person's anal or genital cavities. It says where a strip search is to be performed, there must be particular individualized facts known to the police justifying subjecting the person to that procedure, which I think is more or less the same as specific facts to support a reasonable suspicion that they have secreted contraband underneath their clothes. I think that's what the policy says.
Yeah, I think so.
Okay. All right, so I think we've been through everything. Are there any other issues to raise at this time?
So it looks like we're good.
That way.
Marlene,
Yeah.
Janet, Marie. Marie's, you still there with us?
Yes.
Good.
Captain Spencer. Chief.
It's
Thank you.
about an hour past my bedtime.
Oh.
So
I'm still trying to eat my dinner.
All right, everyone. Karen,
Thank you.
You're gonna get back to us with the document before we go to the general committee, or is this it?
No, at this point, Bernie, there is no time. We'll
Good.
write these up and we will send the copy to the full committee, and we will also release it to the public. We're running out of time.
All right, Karen, can I see them first?
Absolutely.
All right,
Very good.
because me and you need to talk.
Okay.
All right, when we can talk about that later, but we need to talk.
Yeah, I'll be available on Sunday, even if you want to
Are you
talk
gonna
on
be
Sunday.
back? Are you gonna
Chad.
be back in New York?
Yes.
You'll be back in New York? Okay, Sunday's good.
Okay, very good
All right.
then.
Set aside some time for me anytime.
Okay.
All
Thank
right.
you. Thank you, Janice.
Thank you,
Thank
everyone.
you.
Thank
Thank
you,
you.
everyone.
Everybody.
Good night,
all
everybody.
right.
All right,
Good
everybody
night.
have a good night. Thank
Good
you.
night.
Night.
All right, bye-bye.
Bye-bye.